and colleague, Land Use Counsel Natalie Kuffel, who will take you through the hour today. So just waiting for folks to stream on in. We're at about 300. The capacity for this is 500. So if we max out, we are streaming live to YouTube. And you can find the Governor's Office of Planning and Research's YouTube channel at opr.ca.gov. And there's a nice little YouTube bubble in the heading of our website there. And you'll be able to watch this live on YouTube if we max out of slots here in Zoom. So again, thank you for joining us. I think YouTube has just joined us, so we'll be getting started shortly. Thank you. Another minute? Give it another minute. Folks are still streaming in, actually, or taking their seats in our OPR Zoom facility, virtually and socially distanced facility for you. Thank you for joining us this afternoon. I think this would be a great time to hand it over. Again, you've joined us for our CEQA 202 series. What is a project under CEQA, the California Environmental Quality Act? And I'd like to hand it to my colleague, Natalie Kuffel, our Land Use Counsel for the Governor's Office of Planning and Research. Good afternoon, Natalie.
Thank you, William. And thank you everyone for joining us today as we kick off our CEQA 202 series. We're going to start at the beginning of the CEQA flowchart with what is a project under CEQA. And leading us off will be Jeannie Lee, our senior counsel here at OPR. And we are lucky to be joined by two special guests, Leslie Walker and Jeffrey Herron, both senior deputy city attorneys at the city of Sacramento, who will be discussing the distinction between ministerial and discretionary projects and some exciting new developments at the city of Sacramento to streamline housing production using that distinction. As William mentioned, I'm Natalie Kuffel. I'm the Land Use Counsel here at OPR, and I'll be guiding you through our webinar today. And I'm joined by Alyssa Montanez, our special assistant who's helping with technology, and William Walker, who you already met, our associate planner, who you'll see again at the end to talk about upcoming webinar Wednesdays. As William mentioned, we will have a Q&A section at the end of the presentation. But as you think of questions, please put them in the Q&A box at the bottom of your screen. And we'll get to that probably in the last 10 minutes of our presentation today. So without further ado, I will hand it over to Jeannie Lee, our senior counsel, to get us started.
Thank you, Natalie, and William for kicking us off today. Again, I'm Jeannie Lee with OPR. Thank you all for joining us for this CEQA 202 series. It's the inaugural event, so I'm thrilled that Leslie and Jeff could join us today. So we are intending this series to be for people with a basic understanding of CEQA and for those who want to know more or would like a refresher. So as Natalie said, today's topic that we're starting off is what is a project under CEQA? And we hope that the next hour will be engaging for you. We have a lot of content, so let's just get started here. And I'm trying to advance this slide. There we go. Okay, so today we are starting with this foundational question. What is a project under CEQA and what are some of the related concepts? So as you can see in this chart, the first substantive question to knowing whether CEQA may be triggered by your activity is whether the activity in question is a project. So it's that first step here with the red arrow pointing to it. So let's start with the definition. The Public Resources Code section 21080 subdivision A generally says that CEQA applies to discretionary projects proposed to be carried out or approved by public agencies. So if you don't have a project, CEQA does not apply. CEQA defines a project as an activity directly undertaken, supported, permitted, or authorized by a public agency, which may cause either a direct physical change or a reasonably foreseeable indirect physical change in the environment. CEQA does not apply to proposed projects that are not approved, denied, or rejected. So you can see on this slide that I have bolded and italicized certain words. So those are really the key words to be thinking about when you're asking yourself, does my activity trigger CEQA? Is it a project? So we'll go into the meaning of these words in a little bit more detail later on in this presentation. So a project may also include private activities that have some kind of public agency participation, such as through public funding. An example would be if a private activity is getting a public grant or a loan. Other kind of public agency participation could be a permit, license, or some other kind of assistance. A simple example would be if you have a private housing development project that may require a conditional use permit and any other entitlements from the local agency. So in that situation, it may be a project subject to CEQA. Finally, when we are talking about a project, we are referring to the whole of the action and to the underlying proposed activity. The underlying proposed activity may include several governmental approvals, such as in the previous example that I just gave, a conditional use permit. A project does not mean that does not refer to the governmental approval itself, such as the CUP, or in some other cases, you may need a general plan amendment. So the project is not just the general plan amendment, it is the underlying activity. So related to this concept of the whole of the action, a public agency cannot break down this project into subparts and only look at those subparts individually to avoid looking at the environmental impacts as a whole. So, like I said, these are the key points here: whole of the action. You need a direct physical change or a reasonably foreseeable indirect physical change in the environment. There has to be a discretionary activity here as well. Oops, sorry, I forgot to advance this slide. Some common examples that are listed in the Public Resources Code and the guidelines include clearing or grading of land, enacting or amending zoning ordinances, and adopting and amending general plans. These are not necessarily projects as a matter of law, but they are activities to which CEQA might apply. Under the guideline section 15378, it also lists out activities that are not projects. Two examples here are legislative proposals to be enacted by the state legislature. And the reason why that is because the state legislature is not considered a public agency. Another activity that is not a project are when government funding mechanisms are created that don't involve any commitment to a specific project, which may result in a potentially significant environmental impact. So now that we've gone over the basics, we're going to go into some of the more finer points of the definition of a project. And as Natalie mentioned, Leslie and Jeff are going to be going over the distinction between discretionary and ministerial activities. But first, we are going to take a short quiz, which Natalie is going to kick off.
Great, thanks, Jeannie. So before Jeannie tells you the answer, we're going to do a little pop quiz. And you should be able to see this now on your screen. And the question is, for a project to be subject to CEQA, there has to be an approval by a public agency of that project. Would an agency's mere expression of interest or support be a project approval? All right, and the votes are coming in very quickly. We are a little over 64% participation with 504 participants on the call. So I'm going to end the polling and we'll see the results. Okay.
Great. We have some
So
great students here.
Yeah, as you can see, 7% thought yes, that was enough for it to be a project. 93% said no.
Great. Thank you, Natalie. And I'm going to go to the next slide. An approval is defined as a public agency that commits the agency to a definite course of action in regard to a project intended to be carried out by any person. So in answer to that first question, an agency's mere interest in or inclination to support does not constitute a project approval. So there isn't a bright line test for when an agency's decision is a commitment to approve a project, but you may have heard this seminal case from 2008, the case of Safeterra versus City of West Hollywood. It gives us some good guidance in particular about when there is a commitment to approve a project. So in that case, the Supreme Court was looking at whether the city's conditional agreement to sell land to a private developer was a project approval that should have been preceded by CEQA review. And the court laid out a very fact-specific test to be applied on a case-by-case basis. The key point that I want to mention here and to keep in mind is whether the agency has committed itself to the project before doing CEQA review, such that the agency did not have any discretion to require any alternatives or mitigation measures under CEQA, including the alternative of not going forward with the project. So in Safeterra, the court concluded that there was a project approval. Some of the factors that the court looked at as being dispositive here included the city's financial support. The city had given a financial contribution to the developer, and also the city had made public statements of support for the project. The court at Safeterra also said that where the agency conditioned the pre-approval agreement on compliance with CEQA, that condition alone did not necessarily resolve the question of whether there was a pre-approval commitment. As a practical matter, the agency could still limit its ability to require alternatives or impose mitigation. So if you've been following the latest round of the CEQA guidelines update, which occurred in 2018, you may have noticed that the latest round of updates included a change to guideline section 15004. And those changes were based on the Safeterra case, as well as some of the subsequent cases that came after it. So that section and the updates discuss when an agency may enter into a pre-approval agreement without crossing the line into a project approval. So aside from needing a project approval, another key requirement is whether the project may cause either a direct physical change in the environment or a reasonably foreseeable indirect physical change in the environment. And that comes from Public Resources Code, section 21065. An indirect physical change in the environment is defined as one which is not immediately related to the project, but which is caused indirectly by the project. A reasonably foreseeable indirect change is one that the activity is capable, at least in theory, of causing. Speculative impacts, or those unlikely to happen, are not reasonably foreseeable. There has to be a causal connection between the activity and the indirect impact. You may have noticed that guideline section 15064 subdivision D2 gives an example of an indirect impact. And that section says, gives this example. The construction of a new sewage treatment facility that may facilitate population growth in the service area due to the increase in sewage treatment capacity and lead to an increase in air pollution. And there definitely in the case law, there are many other examples. And so we're going to go through some of them. But first, another question.
Great, thanks, Jeannie. So we're going to launch our next question, which is, are a public university's increases in student enrollment a project under CEQA? I think we're really testing your knowledge of very recent CEQA case law on this one.
Yes, that's right. I tried to pick cases that were more recent.
In. Yeah. Yeah. Okay, we're almost to 60%. So I'm going to end the polling and you'll see whether there was a clear winner on this one. Okay. So this one, everyone was pretty split with 48% thinking yes, that would be a project under CEQA, and 52% saying no, that would not be a project under CEQA.
Very interesting. It would be interesting to, I haven't looked at, I haven't verified whether the court actually had a split of opinion or how they landed. So that would be kind of interesting if they did. So what is the answer? Yes, the answer is yes. So this is a recent case. I can see it's from 2020. According to the court in Save Berkeley's neighborhoods versus the Regents, that the university's increase in student enrollment did constitute a project. So this case revolved around a 2005 program EIR prepared for the long-range development plan for the UC Berkeley campus. And by way of background, the university is required to prepare an LRDP on a periodic basis. So that plan said that by the year 2020, student enrollment would increase by 1,650 students, and that the university would add 2,500 beds for students. So here, the petitioner Save Berkeley's neighborhoods claimed that well beyond the numbers analyzed in the 2005 EIR, the university continued to approve student increases without doing CEQA review. And by April 2018, the university's actual student enrollment was about 8,300 students. So that is, again, the numbers are anticipated student enrollment would be 1,650, and by 2018 it was 8,300. So petitioner here argued that the increased enrollment caused by the unanalyzed environmental impacts included the increased use of off-campus housing by students, which would thereby lead to increases in off-campus noise and trash, as well as increased traffic and increased burdens on the city's public safety services, such as police, fire, and ambulances. So the petitioner again said none of those impacts had been analyzed. Again, the court said the increased enrollment is a project under CEQA that requires environmental review, and that substantial changes to the original project triggered the need for a subsequent or supplemental EIR under Public Resources Code section 21166, especially where the increase caused significant impacts not analyzed in the 2005 EIR. Here, in coming to its holding, the court pointed out that CEQA does require public universities to mitigate the impacts of their growth and development, and they specifically pointed to this 2006 case called City of Marina versus Board of Trustees. In this context, growth includes student enrollment increases. The court also pointed to the Education Code, where it says that the legislature also acknowledged that increases in student enrollment may negatively affect the surrounding environment. Thus, here the court said that the legislature intended the university to analyze and mitigate significant off-campus impacts related to campus growth. So on to the next question.
All right. So we've launched the poll, and the question is, Could a local ordinance allowing for medical marijuana dispensaries foreseeably result in direct or indirect changes to the environment and thus be a project under CEQA? Okay. We're voting very quickly on this one. All right, so let's see the results. So this one, people were a little bit more sure. 80% said yes, that would be a project under CEQA, and 20% said no, that would not. So what is the answer, Jeannie?
The answer is yes. And this fact pattern comes from a case decided recently by the Supreme Court last year. This case is called the Union of Medical Marijuana Patients Incorporated versus City of San Diego. In this case, without doing any CEQA review, the city here adopted an ordinance which basically amended existing zoning regulations, which would allow for the establishment of medical marijuana dispensaries. This particular zoning ordinance also placed a cap on the number of dispensaries and regulated their location and operation. And the city here didn't do CEQA because they decided that the ordinance wasn't a project, since the ordinance itself did not have the potential to result in direct or indirect changes to the environment. Ultimately, however, the Supreme Court disagreed and determined that yes, the ordinance was indeed a project. In particular here, the court said that allowing for these new businesses could theoretically cause indirect physical changes, such as causing new retail construction to accommodate these businesses, and also potentially cause a citywide change in traffic patterns. So these indirect changes were sufficiently plausible here for the court to find that the ordinance was a project. The court also importantly stated that the likely actual impact of an activity is not at issue in determining its status as a project. Okay, so we're going to go to our next and final quiz question.
All right, and it is launched. The question is, an agency decides to transfer land to a buyer, but the future use of the land is unknown. Is the sale a project under CEQA? This is similar to some of the questions we've already received in the Q&A box, so hopefully the answer will be helpful to folks. All right, get your answers in. We're almost at that threshold, and here we go. This one slightly more split. 32% of respondents said yes, that would be a project, whereas 68% said no, that would not be a project. So what's the answer, Jeannie?
The answer in this particular case is no. This question and fact pattern refers to the case called, it's a 2007 case, it's called Friends of the Sierra Railroad versus Tuolumne Park and Recreation District. So this case involved a recreation district sale of land to a tribe, and this particular parcel of land contained a historic railroad right-of-way. In doing the transfer of land, the district did not do any CEQA prior to this sale. And interesting to note here is that the tribe owned the surrounding property, and they had publicly come out and said that they would be developing that surrounding property, but they had never submitted any particular development plans to any public agency. Here, the petitioner, Friends of the Sierra Railroad, sued. They claimed that the sale and transfer was a project requiring CEQA review because it was reasonably foreseeable that the land would be developed and that such development would have an impact on the historic right-of-way. The court here held that the transfer was not a project. The court said that CEQA review here would have been premature because the tribe had no particular development plans that would affect the historic right-of-way. But the court did note that future development will in fact impact the right-of-way. Even so, some plan with an identifiable impact on the right-of-way would have to be on the table before the CEQA review process could be meaningfully carried out. The court also said that although environmental review must take place as early as is feasible, it must also be late enough to provide meaningful information for the environmental assessment. So those are just some key points about what is a project. And I have put on a slide a summary of the key points here. As you can probably tell, whether the activity is a project is a fact-specific question. It is a question that is reviewed as a question of law, but it's based on the substantial evidence in the record. So here are some key points to remember as to what we just covered. If you don't have a project, CEQA does not apply. CEQA applies to discretionary projects proposed to be carried out or approved by public agencies. A project is an activity directly undertaken, supported, permitted, or authorized by a public agency. And the project may include private activities that have some kind of public agency participation, such as public funding. A project has the potential to result in a direct or reasonably foreseeable indirect change in the environment. And I think it's important to note that we're looking at the potential, not the actual indirect changes or direct or indirect changes. The project includes the whole of the action. And then at the bottom, you'll see that some important points about when you don't have a project, those would be, the project would not result in a change to the physical environment. There's no causal connection between the proposed activity and the suggested environmental change. And also, if the impacts would be too speculative, then there may not be a project. So that is my last slide here. So I am going to hand it over to Leslie Walker from the City of Sacramento, and she is going to take you through the next section talking about discretionary versus ministerial.
Thank you, Jeannie. To set the stage for the City of Sacramento's ministerial housing ordinance that Jeff is going to describe, I'm going to review what we know from the guidelines and case law related to the difference between discretionary and ministerial projects. So what's the difference between discretionary and ministerial? The guidelines give us a starting point with 15357 describing discretionary and 15369 describing ministerial. Taken together, these sections say that a discretionary project is one that requires the exercise of subjective judgment or deliberation when the public agency or body decides to approve a particular activity. So examples of these are found in the Public Resources Code, zoning ordinances, variances, conditional use permits, tentative subdivision maps. Jeannie, next slide, please. Oh, am I frozen? Next slide, please.
And did I just advance it? Sorry, no.
No.
Okay, I might be having technical difficulties on my end.
Okay, I'll go on.
Oh, there. Oh,
okay.
no. Is that good? Okay.
That's perfect, thanks. They look exactly the same. Anyway, so a ministerial decision is one where the public official merely applies the laws to the facts and doesn't exercise any special judgment or discretion. They typically involve little or no personal or subjective judgment and on behalf of the public official as to whether or not the project should go forward or how it should go forward. And the public official is typically, or the agency is typically just determining whether there's conformity with applicable statutes, ordinances, or other fixed standards. And the code, the guideline gives some examples of things that are ministerial. Most important for us is building permit. And it says that a building permit is ministerial only if the zoning ordinance really limits the decision-making of the public official, limiting the building permit to three things. Is the building permit consistent with the zoning ordinance? Is it consistent with the building code? And has the applicant paid its fee? The guidelines provide a couple, next slide, please. The guidelines provide a few additional important guideposts for the determination of discretionary versus ministerial. First, the guidelines and the case law clarify that it's up to the agency to determine whether the relevant action is ministerial or discretionary. This is important because to the extent, and we'll see this in the cases, to the extent the agency adopts procedures or ordinances identifying with reason what's ministerial and what's discretionary, that may be given more judicial deference when a subsequent, when an approval comes in consistent with that ordinance. Second, where a project approval involves or contains both ministerial actions and discretionary actions, guideline section 15268 says that the project is deemed to be discretionary. So the discretionary component converts the entire approval to a discretionary one. But as we'll see in a minute, that section doesn't convert every approval with an ounce of subjective decision-making into a discretionary approval for all purposes. And that's because of guideline section 15040, which says in various ways, but in subsection B says that CEQA does not grant an agency new powers independent of the powers granted to the agency by other laws. In other words, CEQA requires that the agency consider the environmental impacts of the discretionary decisions that it's otherwise empowered to make. It doesn't create new authority. Next slide, please. So how have the courts applied these tests? For the most part, the courts have applied what's called the functional test from the Friends of Westwood case in 1987. In that case, the city of Los Angeles issued a building permit for a 26-story, I think 300,000 or so square foot multi-use tower. And due to the size of the project, it had to go through plan check for major projects. Not most projects in Los Angeles don't have to go through that. And the plan check process required the city to make a number of discretionary determinations, like whether the dedications offered as part of the project provided adequate ingress and egress from public streets, and a number of other judgment calls like that. And the code also allowed the city to grant slight modifications from the code where a special individual reason made strict letter of the ordinance or compliance with strict letter of the ordinance impractical. So not surprising, the court found this to be discretionary. The court said that the purpose of CEQA is to minimize the adverse effects of new construction on the environment. And to serve that goal, CEQA requires assessment of environmental consequences where the government has the power through its regulatory powers to eliminate or mitigate one or more adverse environmental consequences that are revealed by the environmental study. And so the court sort of created this two-part test. One, does the government, through its regulatory powers, have the power to eliminate or mitigate one or more adverse environmental consequences revealed by an EIR? If the answer to that is yes, then the decision is discretionary. And the second question is, can a private party legally compel approval of the project without any changes in the design which might alleviate the adverse environmental consequences? And if the private party can legally compel approval, then it's ministerial. So applying this test, the court found that the building permit was likely discretionary based on 5 factors. One, the code called for the public official to exercise subjective judgment. The code allowed variation from the strict requirements of the code. The city actually exercised its ability to grant these variations. And the issues on which the city exercised its discretion were issues where the environmental impacts could have been addressed. So for example, the city exercised discretion on some of the traffic improvements, and environmental impacts at that point could have been, traffic improvements could have been addressed. And finally, the applicant could not have legally compelled the city to issue the permit without the conditions that were imposed during the plan check process. So that's the functional test and how it was applied in that case. We're going to look at a couple of other cases where the issue arises in the context of whether subsequent or supplemental environmental review is required. The issue of whether or not a project is discretionary often arises in that context when someone comes in for, say, a building permit or design review after the project has been approved and environmental review has been completed. And of course, this agency can only require subsequent environmental review if that second approval is discretionary. Next slide, please. So in Health First versus March Joint Powers Authority, the agency used a yes/no checklist to determine whether design plans were consistent with the applicable general plan, specific plan, and design guidelines, all of which had already been approved. And the court found that because the consistency review was accomplished by considering 125 yes/no questions, the decision was ministerial. In that case, the design guidelines had specifically stated that the review of a proposed development did not involve the exercise of judgment or deliberation, but merely a determination as to whether the plans conformed with the existing design guidelines. So there, the agency sort of put a marker down saying what was and was not discretionary, and then in the future complied with that, that earlier determination. Similarly, in San Diego Navy Broadway complex, the petitioners alleged that the City of San Diego's review of construction documents for consistency with aesthetic criteria in a development plan and urban design guidelines set forth in an approved development agreement required the agency to exercise its judgment. And the petitioners argued that because the city was required to exercise its judgment in evaluating things like whether the design of the project emphasized pedestrian access, the decision was discretionary, and the city had to conduct subsequent environmental review to consider a variety of impacts, including the project's greenhouse gas emissions. And the court said that the fact that the agency could arguably exercise discretionary authority to alter the aesthetics of the project to make it consistent with the development agreement did not demonstrate that the agency had the authority to modify the project to reduce greenhouse gas emissions or other impacts, showing us the limits that we saw in CEQA guidelines section 15040. Friends of Juana Brion was not a subsequent environmental review case, but it just has a good rule that a permit is ministerial only if the official decision of conformity or non-conformity leaves scant room for the play of personal judgment. Next slide, please. So more recently, we saw this case of MacCorkle Eastside neighborhood versus the City of St. Helena in 2018. And in this case, the city approved a demolition permit and design review for an 8-unit multifamily project in a high-density residential district where the development was permitted by right, subject to design review. And the design review in the city ordinance required the city to consider 14 design review factors and also prohibited the city from disapproving the project on non-design review factors. So the petitioners claimed that the design review was discretionary and converted the entire approval into a discretionary act subject to CEQA. As we said earlier, where a project involves an approval that contains elements of both a ministerial action and a discretionary one, the project is deemed discretionary. But the court said the discretionary component of the action must give the agency the authority to consider a project's environmental consequences to trigger CEQA. And since design review was the only entitlement, the city's discretion was limited to design-related matters such as general form, spatial relationships, and other appearance-related factors. And therefore, the agency didn't have the authority to consider traffic, public safety, and other impacts that the petitioners alleged needed to be considered. So this again shows us the limits of CEQA's ability to create additional authority for public agencies. Next slide. So these cases give us some comfort, but we have to pay attention because the issue is currently before the Supreme Court, which is considering whether well permits are discretionary. And the Second District Court of Appeal said, no, they are not. And the Protect Our Water said yes, because the city retains some discretion to determine the well placement. So the Supreme Court numbers are there if you want to put a tickler on them to watch how this issue develops. And I will now hand it over to Jeff to tell you how the city is implementing its ministerial ordinance.
Thank you, Leslie. Good afternoon, everyone. This next series of slides is about the city's recent adoption of an ordinance for administrative and ministerial review of qualifying housing projects. One of the precipitating items is here on this particular slide. Sacramento, like 95% of the jurisdictions in California, has not met all of its RENA allocation. And before that, and even before SB 35 came along, which is the state's ministerial process, City Council directed staff to work on a staggering array of programs in order to expedite housing production in the city. Next slide. Here's one of them. On July 28th, the city adopted an ordinance, which in the judgment of City Council is to be a locally tailored ministerial process with the aim of expediting qualifying housing production, delivering cost savings, reducing VMT, and assisting the city in its designation as a pro-housing jurisdiction. I'm told that that's for when you can get preference points or other criteria that will help you apply for housing or other infrastructure grants. And it's my understanding, I'm told, the State Housing of Community Development, the HCD, is about to put out its guidelines and application process. And when they do, the city of Sacramento is going to apply. Next slide, please. So now we have three processes in the city: the city's normal discretionary process, the SB 35 process, and the city's ministerial process. And what I would point out in relation to what was just talked about, the project here was the ordinance itself. It was analyzed through use of an initial study, which concluded it was described in and within the scope of the city's detailed master EIR. Next slide, please. Here, the next series of about 7 slides, we're going to have a comparison and a contrast between SB 35 as it applies to Sacramento as far as triggers and depth of affordability, and the city's local tailoring. We found the state as a good jumping off point. Obviously, the legislature put a lot of thought into SB 35, and they did a really good job, I think, of compiling those ineligible site-specific and other matters for such a project that I think commonly most cities experience, for which you really can't come up with fixed standards that are applied, but even if you could, it might not be desirable. So here we've set up where we have the types of projects that are available for this process. Ours is like the state, residential or mixed use, provided you have 2/3 devoted to residential. Where we are different is we capped it at 200 units. The state doesn't seem to have a cap. I know that when staff first went out with their ideas on this, they started at 500, but in response to community and stakeholders, they reduced it to 200, and ultimately that's what the city decided to use. And also what's different here is, unlike SB 35, we are still complying with our maximum density that's in the city zoning code. Next slide. Now here we have a comparison of SB 35 requiring affordability units and prevailing wage. We didn't have any specific requirements in that regard. The one criticism we did receive was from a nonprofit advocacy group that objected to the ordinance because they thought we should have a build requirement. But in our case, we weren't ready to go there yet, and we're still going to study it. And we were asked to come back to council in a year to see how this ordinance is working. We do have a mixed income housing ordinance, which which would apply to these projects where they pay a fee. Next slide. Here is what I guess you could think of as the setting. We have our definition of infill. The state has its definition and ours is quite similar. It's slightly different in that we talk about existing uses. And if you notice in the HCD guidelines, they talk about existing or former uses. And you'll notice these definitions are quite similar to infill descriptions you'll find elsewhere in CEQA. For example, SB 743, Public Resources Code 21099, I think, or anyway, that has a definition of infill that's just like this, that you'll find similar definitions in other things in CEQA, including some streamlining provisions. And it's also helpful to look at your own definition and the CEQA definitions to when you're using the infill categorical exemption in 15332, which starts out with an opening that says for projects that are characterized as infill. Next slide, please. Here we have some of the items which make a project ineligible for this streamlined ministerial approach. We excluded it from our historic districts, and it can't be a historic resource. The state SB 35 actually would apply in a historic district, but you can't demolish a historic structure. The state also had its own rules on occupancy when demolition might be allowed and regulatorily controlled or otherwise controlled protected units, so to speak. We had our own rules where we don't want any reduction in the total of units on the number of units on the site. And then we also have a rule about occupied units and units that are subject to an affordable housing regulatory agreement. Next slide. Here are some other considerations. We basically used what the state used because these were good exclusion rules that raise issues that probably aren't best try to be dealt with the objective criteria. Where we did add something different is you'll notice we have, you can't be within 1,000 feet of an existing or former landfill. We have noticed that in our discretionary processes, the local enforcement agency, the county for rules on landfills, they have jurisdiction on the landfill itself. But often if there was a development that came within 1,000 feet, they'd use the CEQA process to request that we use our powers to do something about that, including monitoring or perhaps providing impermeable services to stop migration of gas. We thought we are just going to exclude that from ministerial consideration. Also excluded, of course, is any of the other discretionary entitlements you'd need under our planning code, plus something that's in our planned unit developments. Next slide. Now here are some of the I suppose, streamlining things you could think about when you're subject to these. Now, the state expressly said in its statute that the determination of eligibility is not a project under CEQA. No public hearing is required, although they have those rules about having design review and a public board. And they have rules on parking. Ours is also an administrative permit, which we define in our code as ministerial. That's a generally applicable code provision we have for our administrative permits. There's no public hearing. That doesn't mean there's not going to be outreach and opportunity for community to get involved. We have a web-based development tracker that people can sign up for or check on. The project will be routed to the city documented neighborhood groups within 500 feet of the project site. And we have a interesting bold thing in our general code where if it's for a project in a particular council member's district, the council member can ask that the applicant engage in at least one community meeting. We also have our own parking streamlining rules here. Next slide. Here are some of the timelines and other considerations. We use the same timelines as SB 35 for us to get through deciding whether it's a qualifying project. We don't have a deemed consistency rule, and they would be subject to reconsideration at the planning director level. And we've also excluded it from our generally applicable rule that doesn't allow developments to, after a denial, for example, to reapply for substantially the same permit within 1 year. Here you could just keep reapplying if you didn't get it right. I think that might be my last slide, in which case I'll turn it over to Natalie Kuffel, the land use attorney for OPR.
Great, thanks so much, Jeff. And now we're going to do some Q&A for our last 10 minutes. We likely won't get to all questions that are open, so apologies for that, but we'll try to get to as many as possible. And we had 2 questions about grading permits, so let's start there. The first question is from Jenna, who asks, when would a grading permit or grading project surpass a threshold and be considered a project? And how is this generally streamlined by different jurisdictions? So I don't know if Jeff and Leslie, you could answer how the City of Sacramento addresses grading permits. That would be helpful for Jenna.
Hi, our grading rules are in the code. They're hard baked in there and they're specified criteria. I would note that there is an exemption in CEQA for if the grading is for less than 10% of the slope, and it's exempt.
Sure. Thanks. And the other question regarding grading permits, if a project is discretionary due to the grading permit, under CEQA, would you analyze just the grading portion of the project or the entire project?
Can you repeat the question?
Yes, of course. So this question is from Christina Cardinova, and she's wondering, if you did have a discretionary grading activity and you are analyzing that under CEQA, would you also look at the rest of the project or just that grading activity in preparation for a larger project?
So I think if that was the first if that was, typically it's the beginning of a bigger project when you're doing a grading permit. And so in that circumstance, I think you would look at the entirety of the project. If you had already analyzed the entirety of the project and this was just a later approval, then I think it would be limited to just the grading permit.
Great. Thanks, Leslie. Okay. And then the next question from Jody asks, with respect to the sale and transfer of land not being a project, what if there is a reasonably foreseeable development that would result from the sale of the land? Would that be a project?
I think that could be. I mean, in this other situation that I talked about, the Sierra Railroad case, there wasn't an actual thing on the horizon. I mean, there were potential plans, but nothing had actually been solidified. But if there is something and you have facts in the record to support that there is a reasonably foreseeable future use and there are facts to support that, like I said, I think that could be a situation where it crosses the line.
Great. Thanks, Jeannie. So we had another question submitted via email that we can address, which is if you have a project that would not normally be, or if you have an activity that would not normally be considered a project under CEQA, but it receives public funding, like through a grant program, is that enough to convert it to a project under CEQA?
I think you also have to look at the other hallmarks of what a project is. So it's hard to just say right off the bat, yes or no. I mean, there has to be, going back to the summary of key points slide that I had, there has to be a discretionary activity. There has to be an approval, which is defined as a public agency decision that is committing the agency to a definite course of action. There has to be for the project to result in a direct or reasonably foreseeable indirect change in the environment. So but just by itself, the public funding part is not dispositive, and so you need to look at all the other factors before making a determination.
Thanks, Jeannie. So the next question is in response to a case that Leslie covered, the MacCorkle decision. So if for a particular project, everything was ministerial except for a discretionary tree removal permit, say for one tree, would the project as a whole trigger CEQA review?
You know, I think it would depend on the city's ordinance on the tree removal. And I also think we have to be cautious about that decision, because it certainly could be, you know, it was in the I think first district, and you know, we're not in that district. That said, if the only permit you were getting was a tree removal permit, the question is, if the only permit you were getting is a tree removal permit,
yes.
does that convert the entire project into discretionary?
Yes.
I wouldn't think so, but I would think that you would have to consider all of the impacts that could be mitigated as a result of studying the tree ordinance, the tree removal.
Thanks, Leslie.
Mm-hmm.
I will have to say, just in general, the CEQA guidelines does allow, or rather provides for lead agencies to come up with their own sort of administrative manual about how they're going to apply CEQA. And some agencies, what they do is they just adopt the CEQA guidelines wholesale, but others modify it slightly. And in that sort of administrative manual of how they're going to apply CEQA, sometimes people do put in there, these are the kinds of activities that we have determined are going to be not a project or exempt. So there could be some agencies that have determined that the removal of one tree is not a project. So I guess you'd have to look at that particular agency's CEQA procedures.
Thanks, Jeannie. I think this next question could be for you. It's from Ryan, who asks, if several agencies would have discretionary approval of permits for a project, but one agency would have ultimate discretionary authority to approve or disapprove the project, does CEQA apply to the lesser permits or only the decision of the final approving agency?
Well, in this situation, I'm not entirely sure. I mean, I think it kind of depends on what is the underlying activity here and what the actual permits are. So it's a little, we could get some more details on that, but it almost sounds like it could be, this question could be going in the direction of like, who is the lead agency and who are the responsible agencies? It's not entirely clear to me, but certainly follow up in my emails on this slide if you would like.
Okay. And I see we are 2 minutes out from 2 o'clock and the end of our webinar. So I wanted to give some time to William Walker to talk about some other upcoming webinars we hope you'll be able to join us for as part of our Webinar Wednesday series. William?
Great. Thank you, Natalie. And I'll quickly hit on our next 3 webinars so that we can get on out of here at 2 o'clock, respect everyone's next meetings. I'm sorry, yeah, 2 o'clock. August 12th, we're having a webinar on pathways to state service. I'm really excited about this webinar. Our Chief Service Officer for our California Volunteers Program, Josh Friday, will be joining us to talk about the summer service and give you details on how you can get some of your young ones in your lives involved in working on state projects between now and the end of August. And we're also inviting our interns and fellows from both the Governor's Office of Planning and Research and the California Strategic Growth Council to talk about their experiences, especially being interns and fellows in a time of a pandemic. August 19th, we will be talking about federal grants, applications, and administration with Amy Miller, our pioneer for Webinar Wednesdays. And on August 26th, we will be debuting our site check tool, which Natalie Cuffle, our land use counsel and our host today, and Helen Campbell have a lot of involvement with. Natalie, you want to give us a little teaser on that site check webinar?
Absolutely. So for all of you CEQA nerds on our call today, you might be interested in learning about a new tool that OPR will be launching and discussing at that August 26th webinar that shows you where different existing exemptions for housing projects may apply. It's a map-based tool. You can type in an address or zoom in on a parcel, run a report, and get a sense of whether any CEQA exemptions or streamlining provisions might apply for a housing project on that site. It was funded by the Department of Housing and Community Development and developed by OPR. And so we'll be debuting that and walking you through that on August 26th. And it's now after 2 o'clock. So we will let you go back to your day, but we wanted to give a big thanks to Leslie and Jeff for joining us and being our special guests on this webinar Wednesday. So thank you, Leslie and Jeff. We really appreciate your feedback and your presentation today, and to Jeannie Lee, our senior counsel, as well for her presentation. So thank you, everyone, again for joining us.
Thank you, Natalie. Thank you, Alyssa. And I'm William, and we will see you next week.